American education, and some basic legal terminology that we associate with school law and teachers. So let's look at basically what the United States Constitution says about the establishment of schools. What does it say? Well, if you're kind of speechless, you're correct. It really says nothing about the establishment of public schools in American education. The 10th Amendment, however, does say that power is not delegated to the United States by the Constitution, nor prohibited by it to the people, are reserved to the states respectively. So that means that if it's silent, then the states are going to have to come up with something to establish it. And so all 50 state constitutions have clauses, segments about the establishment of public schools in America. Now, a lot of times Articles 1 are going to be used for the legal basis to finance schools. Articles 3 and 4 are sometimes used in tenure and due process legislation. And then a number of articles are used by the courts to set precedents for things like the separation of church and state, for student search and seizure on persons and in locker rooms, and as due process or corporal punishment. All of these have a basis in our Constitution, but they are defined either by the courts or by state constitutions. Now, that doesn't mean that the federal government is not involved in education. If we go back to the 1990s, the National Governors Conference convened, and they came up with 6 goals that kind of precipitated the actions, the money, funding, operation of the federal government's involvement. And these 6 actually were goals that some would say were never met, but we strive to achieve them. For example, number 1, every child will start school ready to learn. In that program, or that goal, well, there was a lot of money that went to preschools and early childhood education. In fact, it precipitated a number of new programs in higher ed for certified teachers in those areas. There was a big push in high school graduation rates to raise them to 90%. And again, it depends on how you count that. It was a big part of the bar game there, but they wanted to increase the number of kids that stayed in school and actually graduated. And then there was a move towards state testing in grades 4, 8, and 12, especially in math and science. And as we later saw some legislation come out, math and science were reading and math were the 2 that got most of the play. And then in 4, we would be the first in the world in science and math. And again, it depended upon if you were comparing apples to apples, whether or not we achieved that. 5, adult education got a lot of additional funding because it asked in the 5th goal that every adult American would be literate. So we did see some good money flow into those types of programs. And then we had a lot of federal money going into school safety and drug programs, so that we had a better environment, a safer environment for our children in the schools. But that was called Goals 2000, and it established some focus for the federal government's involvement. In 2012, George Bush set No Child Left Behind legislation, and it had 5 focuses. with increased accountability. So you had, again, more testing coming down the pike, more choices for parents and students, again, pushes for vouchers and the like, and increase motivation for independent schools to form. There were greater financial flexibilities in how states and districts and schools put their limits on their money. They gave them more flexibility, and then putting reading first as one of the major focuses. They wanted all kids to be able to read by the end of elementary school. And then what affected you the most was recruiting and training of high quality teachers in every classroom. And so you went to more testing of our educational candidates and higher qualifications for those that became teachers. So it did affect what you're doing in higher ed and for certification purposes. One of the drawbacks many educators felt with No Child Left Behind was its 12-year focus for the school districts, where they had to set reading and math goals for their children over a 12-year span of time. And as they tested those students each year, you had to see a progression of improvement, or you were placed on probation. And what the general goal was, after 12 years, all your students would be at a proficient level. Well, as we've got to halfway through the program, you were finding more and more schools were not continuing to increase, and so more and more schools were placed on probation. They got some bad publicity there, but it was almost an impossible goal to reach. But it did increase improvement, at least by the indication of test scores, as schools continue to try to strive to get kids to do better in reading and math. In 2015, the Common Core was developed by the National Governors Association and by the Council of Chief State School Officers. It was not done by as many perceive, as by the federal government, but they developed Common Core standards for math and science. Early on in the program, 42 states accepted the Common Core as their standards that they would use for their schools and their states. And since then, we've had some retractions from that. But for most states, it's still the common standards used for reading and math from in the scope and sequence from K through 12. In 2012, our Kansas State Department of Education received a waiver for No Child Left Behind in 2012 to follow their own accreditation system. They got improvement for that, and it has a number of quality indicators that will be looked at by the district. A lot of data collected to show that there is improvement in just not more than reading and math test score. So educators, I think, are a little bit more accepting in this sort of orientation towards judging whether a school is doing well or not, just not based on two scores, filling in zeros on a Friday afternoon. In 2009, the federal government initiated the Race to the Top program, where they used $4 billion in competitive grants to advance some competitive state reforms. And for those reforms to be accepted for the money, they had to do one of the four things listed here. But they actually had to do with adopting high quality standards that would meet a workplace inequality, building data systems to show that their kids were succeeding, again, recruiting and developing, rewarding our best teachers. So a lot of mentor programs, a lot of staff development money came with the race to the top and the funding. And then in our lower schools, a lot of times found in the urban areas, were receiving some pretty good grants to try to see if they could turn around their major problems. So it was an ambitious plan for comprehensive reform, but not all districts or states participated in it. Then in 2015, President Obama signed the ESSA legislation, the Every Student Succeeds Act, and it largely replaced the No Child Left Behind, and it gave schools a lot more flexibility in student testing and accountability, and it gave them the responsibility for saying what was exactly the level of achievement when we're trying to fix underperforming schools. So there was a lot of flexibility with Every Student Succeeds Act. So the federal government was involved in and has been involved for decades in our schools, but basically it is the Kansas state constitution and every state constitution that legislates the schools. In our state, the legislature is responsible for establishing, maintaining, managing, and financing public schools in Kansas, and that has to offer a free and equal education for every child. Now, remember those two words, free and equal, because do you have schools that charge art fees? Do they charge certain fees? We still have some places where we don't see that happening. And is there an equal opportunity for every child? Well, those two questions came up by school districts and legislatures. And if we look back at 1990, there was one school district in the state of Kansas that had a pupil-teacher ratio of 5.7. For every 5 students, you had one, or every 6 students, you had one teacher. And then in another school, you had for every 20 students, you had one teacher. Now, we count counselors, administrators, and the like also in there. You had one school district that, when you looked at the parents' income per child, you had a low school district of $13,000 and a high where for every kid you had $145,000 taxable income. So much more money coming into certain schools and with lower mill levies. And then per pupil expenditures, you had one school district that spent for each child for that year $2,600. In another school district, it was over $10,000. Now, would that be a free and equal, or would that be an equal education under the eyes of the law when it came to finances? Well, that was a good question. So a number of school districts then filed a lawsuit, and in 1992 Judge Bullock ruled that, and it was a simple ruling, the duty owed by the legislature to each child is to furnish an educational opportunity equal to that owed to every other child. That is, if a child lived in one school district, it should be equal to the one that lives in another. Except as authorized by law, the legislature cannot charge fees or supplemental charges. And third, the educational needs and costs may vary from place to place and from child to child, because you have some school districts that they had to bus kids for, in the rural districts, a number of miles. You might have some school districts that had a lot more special ed needs. And so every school district was not the same. Some needed more money. So a one-size-fits-all for every school district just didn't work. So Judge Bullock's ruling in 1992 kind of set in motion a number of lawsuits that are still in play even today in the state of Kansas. In 2003, they were sued again because they didn't increase much money. and the formula just didn't seem to be working by certain school districts' perception. And so Judge Bullock had to rule again that the legislature is not providing to each child an adequate education opportunity. Now, didn't say equal, it just said adequate this time, owed to every other child. So they even, Judge Bullock even said, the legislature, to properly fund the educational system, had to increase funding nearly $1 billion. Well, that didn't sit real well with the legislature. So again, to come up with $1 billion in one legislative session just didn't happen. So again, it went to courts. And so Judges Fleming, Burr, and Theus heard the arguments from 54 school districts that the legislature had failed to live up to 2006 Supreme Court rulings to properly fund the educational system by increasing funding by $1 million, and it said that it must fund education based on the actual costs needed to get students ready for college or workforce, not on what the coffers had each year. So that set in motion another set of actions. And so in 2015, again, the same three judges ruled that Governor Brownback's block grant funding failed to distribute more than $4 billion a year so that all children receive a suitable education. The state appealed the ruling to the Supreme Court, and we are still fighting that in the courts. So we don't know where it's going to end up, but we are seeing more money going into the public coffers in each of the school districts. So we did have the courts involved, in essence, in funding and providing a free and equal education for every child. But what really runs the state school system is the State Board of Education. These are 10 people that sit on a board, and they implement the legislative mandates. They can't just do whatever they want. The legislature will sometimes tell them they have to do certain things, like add a class on Kansas history, which was done a number of years ago, and so they did that. But they also are set policies to provide a quality educational system in the state of Kansas. So these 10 members are elected for 4 years to represent the 10 districts. I ran for District 9 back quite a long time ago. Got 34,000 votes, but lost by 3,000. So didn't get to sit on the board, but it's an interesting endeavor to run. That state board then hires a commissioner of education. We've gone through a lot of commissioners over the past 20 years, but he is responsible for implementing the policies of the State Board of Education and the legislature. And if you see all the faces there, we've gone through quite an array of different commissioners. But the Office of Commissioner is one of the major departments. The second one is the Educational Services Department, which oversees the programs in their public schools. Dale Dennisher has been the financial services overseer for a number of years, keeps the state and the school districts making sure they do everything legally right to finance their schools. And then you have a vocational and community colleges section. You will deal with the educational services section when you apply for certification. Well, the State Board of Education can't really oversee all of the school districts in the state of Kansas. When I first came to Pittsburgh State in 1989, there were 316 school districts in Kansas. I think we're down to 392 now. Don't quote me on that, but we haven't consolidated much, but we have a lot of small school districts in Kansas, but they all have a local board of education that are elected by the people in each of the school districts, and they're empowered by state law to administer the school system in their district following state and federal guidelines. I ran a number of years ago, and because I didn't see any way for my kid to get through school and graduate unless I was the president of the board. And oh, just joking, but I got to give him his diploma when he graduated from high school, so that was kind of fun. But the functions of the local board are three. They set policy, like your calendar, the curriculum we're going to teach. They're judicial. They handle student expulsions, dismissal of principals or superintendents or service staff, and then they're ministerial in duties and like giving out diplomas and the like. So local boards take a lot of time for those members to serve, and it's usually a very rewarding experience in most school districts. Well, the school district then, they're usually not educators, so they hire a district superintendent. He's responsible for administrating the local schools under the direction of the board. He serves at the will and whim of the board. He can be fired tomorrow. Don't have to give him a reason. He has no tenure. But he serves at their will and whim. And he's responsible then for hiring the principals and the teachers. And in most of the larger school districts, you'll find that the district superintendent gives the principals the responsibility for hiring the teachers, and then he approves them and the like. But the principals are responsible for administrating the individual school, and then the teachers, your job is to fulfill your contract set by, in the state of Kansas, a negotiated agreement. And those negotiated agreements there, if there's 292 school districts there are 292 different contracts, so they're not all the same. Well, under that structure then, things sometimes happen that policies are set but really aren't constitutionally correct, or there are some flaws in them, so that's when the courts intervene. Not everything is what it always is set to be. So guess the video is not going to work, but yeah, it is. Well, sometimes things aren't what they seem to be, and so that's when the courts step in to decide what really did happen. So when you look at the legal structure of the court system, you have two different systems, a state court system and the federal court system, but it always starts, if there's something wrong in the school district, it starts with the decision of the board. If that's not acceptable, it goes to the state district court, and if that's not acceptable in the appeal, it goes to the state appellate, and then if that is appealed, it's to the state Supreme Court. If it's a constitutional issue, again, it's decision of the board, then if it goes to the federal district court, and if that's not, if it's appealed, it goes to the Federal Court of Appeals, and then the United States Supreme Court. So you have a system of handling policies and procedures, and if it's constitutional, it goes to the federal, and if it's not constitutional, it goes to the state court system. Well, let's talk about some legal terminology, and I'll give you some stories as we look at these. But as we look at cases of negligence and things that happen in schools, one of the terms that they're used is pure accident. It is simply an accident where no one's at fault. That is, two fifth-grade kids, it's baseball season, they take their mitt and glove and they go out and they start passing ball, and just one of them missed the ball off his glove. It hits him in the eye, and he loses his eye. later on. Pure accident. As teacher was out watching the playground duty, the kids were just playing. Pure accident. So those things just happen. So pure accident. The second one is contributory negligence. These are where there are situations where the injured party, that is the student, did something that contributed to the accident, and she shouldn't have done it. For example, if you're told in a shop class to wear your safety glasses, and you walk through the shop class without your safety glasses, and a wood chip flies off from one of the saws, hits you in the eye, you lose your eye. It's contributory negligence, because you contributed to your own downfall by not following the school policy. So comparative negligence, a lot like contributory negligence, but comparative negligence is where both parties contributed to the accident by doing something that they were told not to do, but the accident occurred because of an unsafe condition. So both parties, the school as well as the student, was at fault. For example, you have a rail loose in the second floor hallway by the steps. It's a loose stairwell, and a kid's running after the bell rings as he leaves class, and he hits that rail, and it breaks, and he falls over and lands on his pencil and loses his eye. The school was at fault because they had a loose rail, but the kid was running and probably would not have gone over the loose rail unless he had been walking. So the courts will decide who's by breaking up the suit, who gets what based on the comparative fault. When you participate in a school activity, or you just even get out of bed, you assume some risk. And so anytime you participate in something like a cooking class or a field trip or extracurricular activity, you assume some risk. And the courts will look at three things in the assumption of risk. Was there adequate instruction? Were they taught exactly how to do that? And so almost always in tech classes, woodshop, home ec, you have safety tests on how to use different instruments so that we can show the parent that yes, we taught that, here's the test, so you got 100 on it, and the like. Second, they look at what the equipment was like. Was it adequate? Was anything broken? And if the equipment was broken, probably the assumption of risk falls. You're going to find the school negligent. And was the teacher there? Were they properly supervising the students so that they could have stopped any rowdy behavior? For example, if a student has taken his test on how to cook, use the stove, it's on file, they're paired with 2 or 3 other students in the kitchen lab, teacher is moving around well in the lab and is present, and a kid just puts his hand down on the burner and burns his hand, then it's probably a pure accident because there was appropriate instruction, adequate equipment, and proper supervision. Let's say though you give a kid a football helmet that's out of date, that's over so many years old, and it has been cracked before, and so he goes out and he's told not to really practice hard with it, get hit with it, but he goes out, tries to impress the coach, and though the coach was present and he was taught how to block, since the helmet was defective, if he gets hurt with that helmet, then you're going to lose that case because one of the 3 was not met. So assumption of risk applies. There are 3 things that judges will look at. to find out if you're negligent. So let's look at them. For example, if you had a 7th grade gymnastics class and you ask the little girls how many of you can do an aerial? Well, most 7th grade girls will say, yeah, I can. They raise their hand, and maybe they don't even know what it is. And so one teacher asked their students, okay, show me if you can do an aerial. And she provided no spot. And an aerial is where you do a flip without using your hand. And so hands as a cartwheel. And so third little girl tries it and falls and breaks her arm. How's the school going to rule on the assumption of risk? She was on a mat, and this teacher was present, but was there adequate instruction? Probably not. You're going to be paying the girls hospital bills, and possibly if a parent goes after you, lose your job. If you send kids out on the playground and you know one of the swings are loose, you don't tell kids about that, and swing comes undone when a kid is swinging. Of course, you're going to probably lose the suit on that one. A couple of little things too that I need to mention to you. I would never suggest you leave a student in a classroom after school by themselves. You just don't know what may happen. Even though it's after school, they're still using your facility. If the kid gets hurt or breaks something, you're still responsible. You can't, as you leave the classroom, really leave another student in charge. That's not going to hold up in court. One of the big things that coaches do, I've done it, I'd send another student off to get off school grounds to get some food, some Burger King stuff before practice. If a kid gets hit by another car, you're still responsible. Just don't send kids on errands off school grounds. Journalism teachers, when they go out for ads, that's all cleared by signed waivers by the parent. If you want to take a student home, I would tell you never to do that unless it's your own kid. But because let's say, when I was in West Virginia, 4 coaches over the 1 year were accused of, no, one coach was, we had 4 cases of accusation of child molestation, but one case was a coach who took a kid home. He's a male, and he later benched the kid, and he then accused the coach of taking him to his house, letting him drink a couple beers, and that's hard to defend. Typically, if you put that in the papers, makes papers, who will the public usually usually side with? So I just never take a student home. You just don't know what they're going to say. And the same thing applies with being alone with a kid in a classroom over lunch or after school. If that occurs, and it's going to happen, but you always leave the door open. Never lock that door, and stay open, and I wouldn't stay any length of time with one student, but avoid being alone with any one kid. And then, of course, every year teachers are fired for inappropriate touching, and you just can't touch a kid anymore. It's what I tell the secondary teachers. Elementary, they want to hug you all the time, and that's great, but there are appropriate hugs and inappropriate hugs, and I think you know the difference. But for you secondary teachers, I just wouldn't touch a kid. I remember coaching, being a basketball coach. The girls basketball coach got sick 1 week, and so I had to take over his practices and one of his games, and so I always had a habit, probably wasn't a good habit, for the guys. Sometimes spark them up. I'd send them into the game and hit them right on the rear. So I sent this little blonde-headed girl in as a replacement, and I hit her right on that cheek, and boy, you could hear it through the whole gym. And I thought, oh my gosh, I knew as soon as I did it, it was inappropriate, and I thought, okay, I'm going to get hauled on the carpet tomorrow. But nobody said anything because I just I don't know. I got lucky on that one, but I apologized to the girl later. But you just gotta watch how you touch, because that can get you in a world of hurt. Let's talk about my wife, attractive nuisance. Well, there you go. I get in trouble again. But the conditions of attractive nuisance, so these are conditions in a classroom that attract the students, but they're not at the same time potential danger. For example, we used to have trampolines in schools. We don't anymore, but we do have unsecured climbing ropes. If it's not secured against the wall that they can break down, you know, if you got a little fifth grade kid coming to the gym after school and he sees that rope hanging down, he just may climb it, and if he falls and gets hurt, that's an attractive nuisance. Unlocking chemicals, having your chemicals in a biology or chemistry classroom is a no-no. Kids can get in there and fine. In fact, one of the stories happened in Kansas, a small rural school. It had middle school, elementary, and high school all in the same building. And so these kids, they had some acid that would eat things up. And so these two boys stole this acid. They were going to go mess with it. And it was in a glass jar, which is a no-no anyway. And they took it out, and getting to their car, they found, gosh, too many people here. So they put it behind a bush, and they'd come back and get it that night. And this little second grade girl found that acid walking to the bus, and she was going to take it back in to the teacher. Said found something, and she fell and tripped, and it broke, and it hit her face, and she was disfigured by the lost her eye. And so that case was an actual case. Didn't lose her eye, by the way. But how do you think the courts would rule? This was an attractive nuisance. Could the teacher have foreseen that they would get in there? Well, possibly. But was it unlocked? Could they get to it? Yes, it was. And so just by being an attractive nuisance, teacher was held partly responsible for that occurring. A tort is a wrongful act on a person or property or reputation, and it used to be they couldn't sue teachers, principals, superintendents before 1980, but now Kansas Tort Claims Act allows them to sue. And so the boards all now have a liability insurance policy for you to defend you. It's usually about $1 million. However, I've been a board member, and we were sued several times, and we represented the teacher, but with our own lawyer. But is our lawyer looking out for the teacher's interest or our interest? Well, it'd be looking out for the board's interest. So a teacher also needs to have their own counsel. Those usually are provided by, if you're a member of NEA or the AFT or the other teacher union, they have legal counsel, and they also have a $1 million policy on you too, to protect your personal interests. So I always highly advise that teachers become a member of a professional association, just because of that liability that could happen in your career. So basically, if you look at school law, the number one responsibility of teachers is the safety of the students. Above all, when I send my kids to school, now my grandkids to school, the number one thing I expect is that they will come back safe. They will come back hopefully better than I sent them. And so if they come back hurt or psychologically damaged, then I'm going to look at negligence, yeah, because um, I want my kids to be safe. And so negligence is any conduct which falls below the standard, what a reasonable and prudent person would do or not do. And so that's a legal term, reasonable and prudent. And when you look up those terms, they mean careful, shrewd, conscientious, discreet, wise. And so that's what judges rule on. That's what juries will rule on. What would a reasonable and prudent person do? And so in deciding what a reasonable, prudent person would do, they look at several things. And so let's look at those several things. Was there a duty of care? And with that duty of care, was there a test of foreseeability? That is, did they act like a reasonable and prudent person to protect those students? Could a reasonable, prudent person foresee the harmful consequences of the act? For example, a fifth grade teacher was asked by the mother in a note to keep her child in from recess, and so the teacher gave the little girl, who was a well-behaved little girl, a watering can, said, "Why don't you water these plants while we're gone?" And then all the plants were across the windowsill, and the water sink was right there beside it. She had everything she needed, and so she kept her in. And so she started watering, and then she decided, well, I think there's even a better water can in the closet. So she went back into the closet, and up on the top shelf was another watering can. And so she climbed up that case and fell. Actually got hurt, lost her eye, and the mother sued. Because there was not a duty of care. Well, the teacher defended herself by her lawyer through the test of foreseeability. Could a reasonable and prudent person have assumed she would have climbed that thing and fallen off and gotten hurt? She was given instructions to do this and that, and even though she wasn't supervised, she was a good girl, no reason to believe that she would do something different. There were teachers out in the hallway and the like, and so judges ruled in favor of the teacher. Let's say also you had, as another example, a 12th grade college prep class taking a Shakespeare test. The teacher wanted to get some coffee, so she runs down to down the hall to get some coffee. She had already given proper instructions to take the test. Everybody was right and quiet. She left, and a little girl sitting in the middle of two boys was sitting in the middle of two boys, and one of the boys on the left side asked, "Hey Bob, my pen ran out of ink. Can you give me another pen?" Yeah, and so as the boy was getting his pen, he just threw it over to his buddy, and as he was throwing, the little girl kind of looked up and around, hit her right in the eye, lost her eye, and teacher again was sued for the dental optical bills. And so judge ruled, well, the teacher defended herself with a test of foreseeability. Could you have foreseen in a 12th grade college bound where kids are on their own, you've given them instructions, they were all doing fine, that a kid would need a pen, that it would be tossed, and a little girl would be hit in the eye? Again, this jury sided with the teacher. Again, there was no supervision there, and that was the argument for the little girl, but the test of foreseeability won out on this. So you just almost never know sometimes how a jury or a judge is going to rule. Second thing that they're going to look at is breach of duty. Is there something that you did or failed to do in your responsibilities to supervise students that caused that? For example, if you take your fifth grade class out to play baseball, the girls against the boys, and let's say, and you decide to go in and get some coffee, well, doggone, when little boys like little girls, sometimes at that age, they actually like to hit them. And so Bobby started throwing little rocks at his favorite girl. And then she said, well, okay, I'm not going to have that. So she started throwing rocks. And then in just a couple of minutes, her friends started throwing rocks. And so you had a rock throwing incident while the teacher was gone. And well, teacher comes back, and there was a little girl, lost her eye with a rock hitting her. Well, how do you think the judge ruled there? Was there a breach of duty? Yes. Could the teacher have stopped it by being there? Yes. And so by the lack of proper supervision, which you could have stopped, you're probably going to lose that case. That's what, and also if they tell you to be in the hallway during break time, a bell schedule, make sure you're there, because if a fight breaks out and you're not there, you're probably going to get in trouble. Same thing with bus duty. If you're not on bus duty for whatever reason, buses come in, kid gets shoved in front of the bus, you're probably going to lose your job just because you weren't there, because you failed to properly supervise student teacher. So always do your hall duty and bus duty, just in case something happens. One of the quick things, always, how do you break up a fight? A couple little tidbits I would suggest here. If two boys start fighting out in your hallway and they're bigger than you, one of the things you don't want to do is step in between them, because if you get hit, your kids are going to get expelled because they hit a teacher, and that's not your intent. Never sneak up behind them and try to grab one of them, because if you grab one of them, the other one may start pounding on, and this happened actually in a school, start pounding on the other kid, and the parent accused the teacher of holding his kid while the other kid pounded on him. So those two just don't work. What you do want to do possibly is look around at all the kids that's around and taking bets on the fight. Pick out the most responsible kid and send them to get help, or if you have a hallway call button, call for help. And different schools have different policies on this. Some of them, you don't even try to break up the fight. The school resource officer will. So you follow that policy. But you always get help, typically if they're big kids, bigger than you. Now for first graders, just cover up, go in, separate the two. But bigger kids, you got to watch what you say. The best way to do it, a lot of times, when boys fight, I find that they fight for show, and if you use your voice in the most assertive tone possible, it usually stops it, especially if you call them by name. And then never send them down to the hallway or send them to the office by themselves. You're going to want to walk them down. Even if you have to leave your class, you walk them down, get somebody to take your class, and because the fight may break out on their way down to the office. So breaking up a fight is something you're probably going to have to do at one time or another, but just watch how you do it. You do not want to manhandle the kid as you break up a fight, because you leave bruises on the kid, parents are going to come back sometimes on you. Third thing they look at is causation. What did you do or fail to do that had a relationship in the injury? For example, if you don't give any kid a safety test on the use of the radio saw in a industrial arts class, or how to use certain dangerous equipment like knives in a family consumer science class, and you don't have it documented, probably may have a hard time defending yourself. But what you did had a relationship in the injury. If you don't replace that safety gauge on the radio saw, and you let a kid use it without the safety gauge, that's going to cause you trouble too. So look at causation. And then actual damages. There has to be something that occur, like the loss of the eye, as you find. I make up on all these cases. But was there actual loss or real injury? We did have a case in St. Louis where first grade teacher It was Halloween day. It was Halloween, and the kids had dressed up in their outfits, and she had some lighted candles for ambiance in front of her desk. They were all lit in a row, and she asked her kids to line up there in front of her desk. And a little kid had a Cinderella dress on that's all fluffy and the like, a little girl, and it caught fire as she brushed up against the candle and burned a large percentage of her body. And this was a multi-million-dollar suit, and of course they didn't have enough money to cover it all. But would a reasonable, prudent person have set lighted candles on her desk and asked kids to get close to it? No. So the teacher lost pretty well big time. Another thing that I'd avoid is setting a kid in the hallway, because if he's mad, especially if it's a discipline situation, you set him into the hallway. A lot of kids in elementary school may flee in a situation, or in high school sometimes they just want to mess with you. And I know a situation where in a secondary school where a teacher set the child out in the hallway, and he just decided that he was going to go home, and so he just left and got in his car and got into the car accident. Principal called in, "Is Bobby in that class with you?" He said, "No." "Where is he?" "Well, he's out in the hallway. He got in trouble." "Well, you're probably going to lose your job on that one." So basically, there are a number of things courts look for, and the more you know about what they look for, the more you can keep yourself from getting in trouble. Let's see how you would do number one. Here was a 11th grade art class that the teacher took to. There were something like 25, 26 students. He had partnered them up, went to a major art gallery, took some parents with them in pairs. So they had about 5 or 6 pairs, and so they had adequate number of supervisors. And the art tour got finished a little early, so they told them, "You got 20 minutes before the bus gets here, so I want you to, with your partner, to go to your favorite art piece and to try to, in 15 seconds or 15 minutes, sketch that piece, and you decide amongst yourselves which one you want to go to, the two partners." And so these two girls went down to a sculpture in the basement, and the teacher had put, there were 3 stories, and so they put a para or a teacher or a parent at the stairwells of each of those places, so they had locations there and they knew they couldn't leave. Well, it just so happened that 3 young men that were gang members had broken into the art museum, was causing mischief in the basement sculpture place, and they actually raped the 2 girls that went down there, and the suit followed, of course, with inadequate supervision. But how do you think the courts ruled on that one? Did she act as a reasonable and prudent person? Well, in essence, the test of foreseeability came into play big time here. Could you have foreseen that a gang would come into an art gallery and be down there in the basement waiting for some girls or something? That you couldn't have foreseen that they did take adequate measures of partnering up. These were 11th grade students, responsible students. They had put chaperones on certain floors if they had questions or troubles, and so the teacher had done as much as she could. The judge ruled, so there was no judgment against the teacher. Well, now that we've looked at the way that our structure of our schools are legally structured, and we looked at some basic terminologies and what a reasonable prudent person does. In the second law quiz, we're going to look at very specific general legal responsibilities of teachers. So hope you've enjoyed this one. I hope you did well in the quiz. You're fun. And we'll see you in the next quiz. Bye-bye.